Hello everyone, welcome back to lecture 5 on Code of Civil Procedure by Dhriti Dhairya. In the last class, lecture 4, we had started off with pleadings. We had done Order 6, we had done Order 7, and we had also done Order 8 except for the counterclaim and the set-off part. So today, in lecture 5, we will be dealing with set-off, counterclaim, summons and non-appearance and appearance of parties. However, before that, we'll start off a little bit with written statement, or that is Order 8, because set-off and counterclaim also form a part of the same order. We'll sort of just revise written statement. So first thing, let's start with it. So as we had already seen in the last class, it is a pleading of the defendant. It is also not specifically defined. And here, what is the defendant writing? He is dealing with all the material facts that have been alleged by the plaintiff. Here, the defendant is also stating new facts that he is taking in his favor or whatever objections he wants to raise. So rule number 1 of Order 8 is telling us the time limit in which a person has to send in his written statement. That is from 30 days of the date of the summons, and the maximum extension that the court can grant with reasons is that it should not be, the maximum time that can be allowed is not more than 90 days from the date of summons. Now, in the same way as in a plaint, if I am relying on a certain document, I have to produce that document. Same way here, Rule 1A is talking about the duty of the defendant to produce documents upon which the relief is being claimed. Now, Rule 2, what is Rule 2 talking about? Rule 2 is talking about that if I am stating any new fact that I'm trying to bring, that I'm trying to show that the suit itself is not maintainable, or the transaction is void or voidable, or the grounds of defense if it is not raised, or etc., or any such point that I'm taking, I have to specifically plead it. Always from day one, I'm telling you, whenever you're looking at Code of Civil Procedure, try to see it from a logical approach. That, okay, in general, if I am citing a written statement, if I'm replying to someone's allegations on me, what will I write? I will first try and counter all those allegations. Secondly, if I have a new point, then obviously I will write those new points. I should write them separately so that the emphasis can be given. If I'm relying on a document, the documents should be given there. Then if I'm trying to deny, now, as we know, because it is a reply to all the allegations that have been made in the plaint. So what there will be a denial on the part of the defendant that no, the plaintiff is claiming this is not right, I deny such a fact. How the denial should be? It should be specific. You just cannot say, I denied such and such statement. You have to deal with each of them specifically. You cannot deal with them. Rule 4 says that you cannot be evasive while denying them. Just brushing it off one together that, okay, I deny all the allegations. No, he's just telling a lie that I have done such and such thing. You have to you have to put down the background also to an extent. You have to specifically deal with it. And because why it is important? Because Rule 5 is saying that if you're not specifically denying a particular allegation, or if the denial is not being made out by a necessary implication, it should be taken that you are admitting it. Only against persons of disability, such denial is not taken. So now whatever will happen if you're not doing so, if you're not drawing up your WS, if you're not denying that, when their judgment is being drawn, the same will be taken in the favor of the plaintiff, and the decree will also be drawn accordingly. Then Rule 7 is also stating that if you're taking a certain defense, or you're taking putting up the claim of a set-off or a counterclaim, it should be founded on separate grounds. That also you should state distinctly and separately. Rule number 8 is saying, again, if there's a new ground of defense which has come into knowledge or your knowledge after the suit has been instituted, or after you've prepared the written statement, and where you are trying to claim set-off or counterclaim, there also state separately and distinctly. Any subsequent pleadings, as we know, pleadings are found in the foundation. You have already submitted your written statement. Other than set-off and counterclaim, no other subsequent pleading can be allowed. But you have subsequent cannot be made except with the leave of court. But however, sometimes they may allow and fix no more than 30 days for the same. And then we come to rule 10, like what will happen if you're not putting in your written statement as under rule 1 or 9. Again, the court can pronounce judgment against you in order that it deems fit, and decree will also follow on the same grounds. Very logical. What are we seeing? We are seeing the time limits here. We are seeing the duty to produce it. We are seeing how you should deny, how the denial should be there. If you are not denying, it should not be evasive. If you are not denying, then what will happen? It is taken as admitted. Defense of counterclaim and set off should be taken separately. New grounds of defenses should be taken again. They are taken separately and distinctly. Subsequent pleadings, what is the rule? Effect of non-presentation is what, and effect of non-denial is what. That is also needs to be seen. Now, this was something that we had done in the last class. Now we are coming to the new topic, that is set off. Now, what is set off? First thing here in set off is that the defendant is first acknowledging that, okay, this is your particular demand. I acknowledge that you're having the demand from me, but I also have another demand from you. So I'm trying to counterbalance the plaintiff's demand in whole or in part. So rule number 6 is a relevant rule that is here, which tells us what are the particulars of set off that has to be given in a written statement. Now, in this point, you also see that the essentials of a set off is also given. Firstly, a set off will always be claimed in a suit for recovery of money. In this particular rule, it's very important that you should go back and see the illustrations that are there. I'm not dealing with the illustrations here as it will be a really time consuming, but you should go back. I've put down which illustration should be seen where. That will make you understand with much more clarity why such terms have been used. So for the particulars of a set off, first, it should be in a suit of recovery of money. Please see illustration 1 with this. Secondly, the sum of money that you are talking about should be an ascertained sum of money. Third, it should be legally recoverable by him from the plaintiff. Fourth, should not exceed the pecuniary limits of the court where the plaint has been presented. Then fifth, both the parties should have the same character as they do in the suit. And sixth is that it should be recoverable from all the plaintiffs or by all the plaintiffs. How many? If there are 2 plaintiffs, 2 defendants, both the defendants are setting up a claim against the set off against both the plaintiffs. So here what is happening, and when can this be presenting? At the first hearing, but not later. Till the first hearing, you can set up a set off, but after that you cannot, unless you are permitted by the court, and you have to present a written statement which contains the particulars of the debt you're seeking that should be set off. And this particular written statement that contains the set off is construed as a plaint, so that this court will also be able to pass a judgment not only in respect of the original plaint but also in respect of this set off. And if I am writing a reply to this if I'm writing a reply to this set off, then obviously the rules of WS will apply. As again I have stated, illustrations in the Ware Act under this rule are really important. That will help you understand these 6 pointers, that it should be a suit of recovery of money. What do you mean by ascertained sum of money? What do we mean by legally recoverable by him from the plaintiff? What do we mean that it should not exceed the pecuniary limits of the jurisdiction of the court? What do we mean by both parties are filling the same character as they do in the suit, and why it should be recoverable from all of the plaintiffs and by all of the defendants. Now we have understood what do we really mean by set off. Plaintiff has given a demand. I am saying, okay, you have a demand, but I also have a demand against you. So we are trying to counterbalance with both the demands. Now there are 2 types of set offs, that is legal set off and equitable set off. There's 7 differences here. Legal set off, as we know, ascertained sum of money. Equitable set off, it is also allowed for unascertained sum of money. Legal set off is your right. You can claim it as a right. You can go to court and say, yes, I want to set off this and this amount. You have to do so. While in the case of an equitable set off, as you can see from the word equitable, equity, it comes from the word equity. Here it is not a right. It is the court's discretion whether it grants you that particular relief of equitable set off or not. third difference is that in a legal set-off, it is not necessary that the cross demands are arising out of the same transaction, while in an equitable set-off, it will be allowed only if it is arising out of the same transaction. Then in legal set-off, amount should be legally recoverable. Here, equitable set-off, it can be allowed even if it is a time-barred amount. And legal set-off requires a court fee. Equitable does not require a court fee. Rule 6 of Order 8, you see, is dealing with Rule 6, while Rule 6 does not deal with it. Historically, common law courts dealt with it in England. With the legal set-off, and equitable set-off was dealt by the courts of England. So this is all about set-off under Rule 6 of Order 8. I have not dealt with the illustrations as such. I hope you would be doing that part of the reading on your own. If there is any difficulty, please let me know in the comment section so that I will come back to the topic, and then if there is any need, then we can do it with the help of illustrations also. Now this was set-off. Now you can see I have again put it in a nutshell that it is a suit for recovery of money should be there, a certain sum of money legally recoverable, not exceeding the pecuniary jurisdiction. Both parties should fill the same character as a pill in suit, recoverable from all plaintiffs or all defendants. You can only do it till the first hearing and not later. So here also the court should be able to pass a judgment on it along with this original suit. Rules of a plaint apply here. And what is the difference between a legal and an equitable set-off? Now the next topic that we are coming is a counterclaim. Now counterclaim has been dealt under Rule 6A to 6G. Now why, as I had said, when you are keeping prelims in mind, the rule numbers sometimes becomes very, very important. More than rule numbers, order numbers are important. Section numbers are really important. Order numbers are also important. If you can remember the rule numbers, that's very good. And it will even help you in writing the mains answers. Now here, what is a counterclaim? Now here, it is also again a claim by the defendant against the plaintiff, but it is independent and separate from the plaintiff's claim. It is in the form of a cross action. And this concept of counterclaim and set-off was introduced by the 1976 Amendment Act. Now Rule 6A under Order 8 is talking about what do we mean by counterclaim. Counterclaim, a defendant in a suit apart from set-off. If I have claimed a set-off, it is not necessary that it will bar my counterclaim, my right to claim a counterclaim. I can again set up a counterclaim against the plaintiff's claim on any right or claim in respect of any cause of action against the plaintiff which has accrued before or after filing of the suit. However, this I have to do before the defendant has delivered his defense or the time limit for delivering such a defense has expired, whether the counterclaim is in the nature of damages or not. So here again, set-off will not preclude me from setting up a counterclaim, and counterclaim again, it is against the plaintiff's claim only. Now it can be any right to claim in respect of a cause of action which had arisen before or after filing of the suit. Now, when can I put this up? But before the defendant has delivered his defense or the time limit for delivering his defense has not expired. And it does not depend whether the counterclaim is in the nature of damages or not. Here also, the pecuniary limit should not be exceeded. It has an effect of a cross suit. That is, here also the court will be enabled to pass judgment in respect of the original suit, original claim, and the counterclaim. Now, the plaintiff here is at liberty to file a written statement and reply to it, and the counterclaim will be treated as a plaint. All rules of a plaint will be applicable. Now, what is Rule 6B? Counterclaim has to be stated if you're relying on certain grounds for showing that this and such counterclaim exists. You have to obviously state that, you have to specifically write that. 6A is the exclusion of the counterclaim. That is a right of the plaintiff that the plaintiff can go and contend that please do not dispose of this particular thing as a counterclaim, but separate it out, do it independently. And this can be done at any time before the settlement of issues. He can apply to the court. Court may decide accordingly that what should be done. Now, what is the effect of discontinuance of suit? So here what we see in a counterclaim, that the suit in which there is a counterclaim, if there is a prayer for counterclaim, if that very suit, the original suit has been stayed, it has been discontinued or dismissed, it has no effect on the counterclaim can still be proceeded with. Now, what does Rule 6C say? That if there is a default of the plaintiff, because we know that counterclaim is more on the lines of a cross suit or a separate independent suit. Here, if so, obviously it is in the nature of a plaint, and the plaintiff is required to reply to the counterclaim, and if the plaintiff does not do so, the court has a right to pass any judgment against him as he deems fit, as the court deems fit. Now, what does Rule 6F state? That what is the relief to be given to the defendant if the counterclaim is succeeding, if the set-off or a counterclaim is established as a defense, any balance that is found due to either the plaintiff or defendant, you will adjust the amounts, and then whatever balance is left will be given to the parties. And Rule 6G is telling that the rules relating to WS will apply to the reply that is given by the plaintiff to the counterclaim. So this Rule 6A to G is telling you what is dealt with in a counterclaim. Now we need to understand what is the difference between a counterclaim and a set-off. So we see that the first thing is that set-off is a statutory defense to a plaintiff's action, and counterclaim is substantially a counterclaim, a separate independent claim. Then second, set-off should have an ascertained sum of money which is arising out of the same transaction, and there in a counterclaim it is not necessary that it should arise out of the same transaction. Here, set-off is mostly like a ground of defense. You're taking it as a shield. You're trying to cover yourself from the liability that is arising from the plaintiff's side. However, in a counterclaim, it is more like a sword. You can enforce it as an independent action. Now, set-off, the amount must be recoverable at the date of the suit. At the date of filing of the suit, that particular amount should be recoverable. However, in respect of a counterclaim, that particular amount must be legally recoverable at the date of the written statement. Now, in set-off, mostly it is less or equal to the suit claim. And generally, a counterclaim is always for a larger amount. That is, a claim for the excess amount is taken as a counterclaim. So here you see, you are just trying to put up a set-off. You're trying to put up a defense. There you're trying to put up a counterclaim, which is more likely to be independent and separate. Here, a certain sum of money out of the same transaction is necessary in a set-off, while a counterclaim, that is not the case. Set-off is more like a defense, like a shield. You are trying to answer to the plaintiff's claim in toto or in proportion to it. Here it is more than a sword, more like a sword. You can enforce it as an independent action. Amount must be recoverable at the date of the suit. Here, at the date of filing of the written statement. And here it is, amount is less or equal to the suit claim, and therefore a larger amount it can be for an excess. So in a nutshell, again, we can see what is happening with a counterclaim. Here the right is accruing before or after filing of the suit, but before he is filing his defense, again, should not exceed the pecuniary limits. You can take it as a plaintiff can reply, and the rules for WS will apply here. The grounds on which it is based has to be stated. You plaintiff can play for the exclusion of counterclaim from the suit, even if the original one is dismissed, discontinued, etc. The claim can be decided upon, the counterclaim be decided upon. Judgment can be passed against the plaintiff for the counterclaim, and relief can be awarded in what manner you have to see, and what happens if the plaintiff fails to submit his reply, and what is the difference between set-off and counterclaim. That is it to see under WS, etc. So this was Order 8 in totality. We understood about WS. Order 8 was also dealing with set-off and counterclaim. Both of them are two defenses that can be taken by the defendants. Set-off and counterclaim, the distinction is between both of them is important. Why? Because especially on the grounds of when the amount should be recoverable. That is, in a set-off, the amount should be recoverable at the date of the suit, while there at the date of the written statement. So this is all about Order 8. Set-off and counterclaim are important concepts. You need to understand them properly. And if there is any problem in understanding set-off, if there's a need to link it with the illustrations while explaining, I would rather want that you should read it on your own and try to understand it. That will give you a better understanding. But if you want, we can deal with linking of the set-off provisions with the illustrations given in the Ware Act, if that is needed. Now, the next thing is Order 3, that tells us about recognized agents and pleaders. I don't feel it's a very important section, but you can go through it, that who are the recognized agents, who are pleaders, etc. You can go through the same if you want to. Now, the next important section is issue and service of summons. That is under sections 27 to 29 and order 5. So now what have we seen? Till now, what have been done? We had first seen the definitions, we had first then seen the jurisdiction that was there, then we saw the place of suing, res judicata, res sub judice, suits of civil nature. We understood all those concepts. Then we came on how will we institute that suit, who will be the party, how will it be framed, then we went on to what kind of pleadings that we are going to take place. Now, what kind of pleadings have to be presented by both the parties, what will be written in those pleadings. Now, all that has been done. Now, the next thing that will come to is that what will we do with the pleadings? Now, if we remember that in a particular place, we had understood that the moment a plaint is accepted, the next thing that will happen is a summons will be sent to the defendants. Now, so the next topic we'll be dealing with is the issue and service of summons, because now we are assuming, let's take it as an assumption that the plaint that has been presented to the court is proper and that it has been accepted, and now summons has to be issued. Now, how summons has to be issued, we'll see that. So again, summons has not been expressly defined, but it can be said that it is a document issued from a court, which is calling a person to attend the court on a particular date and time fixed for a certain purpose. And so whenever a plaintiff is filing a suit, it gets accepted. Filing a suit, it gets accepted. Defendant has to be informed that you can come here and defend yourself, put up your counter story. And how do we do that? We do that by summons. So relevant sections here are Order 5 and Section 27 and 29. And Section 31 and Order 16 are those which deal with summons for witnesses. So under Section 27, it is said that summons to defendants in a suit duly instituted, it will be issued for answering the claim. And how will it be served? It will be served according to Rule 5 and not beyond 30 days from date of institution of suit. Now, this has to be read with Rule 1, Order 5, which says that summons again has to be issued to a defendant, and where the defendant will be called to answer and file a written statement within 30 days from the date of institution of suit. And it is not required if the defendant is appearing when the plaint was being presented and was admitted. If the particular summons has not been issued, if particular summons has not been given within time, extension for not more than 30 days from, if the defendant fails to appear and file his WS within the given time, extension for not more than 30 days can be given by the court. And how does the defendant appear? He may appear in person by pleader instructed, or by any person who is able to assist the pleader in answering all such questions. And summons should be signed by the judge or officer of the court and should bear the seal of the court. So Section 27 in Rule 1 is giving you first the time limit, that within 30 days, the summons should be issued for answering the claim. In 30 days from the institution of suit, it should be issued for answering the claim. If the defendant is not coming in filing his written statement, then maximum extension of another 30 days can be given. And defendant will not be required to service a summon, to be served a summon when he was present, when the plaint was being presented and admitted. And how will the defendant appear? He will appear in person or by a pleader instructed who is able to answer the question, or by a pleader accompanied by a person who can answer that question. And summons should be signed by a judge or an officer of the court and should bear the seal of the court. Now, rule number 2 is telling that the summons should always be accompanied by a copy of the plaint. Rule number 3 is saying that sometimes when the court feels so, it may also order for a personal appearance. And if it feels that such and such party's personal appearance is important, just by the pleader it won't help, then the court may fix a date. And sometimes by assigning reasons, they can also call for the same day personal appearance. Now, rule number 4 is saying that when a party should not be ordered to appear in person. You can order, you saw in rule 3 that you can order a person to appear in personal appearance, but here you will see when you cannot be ordered. Here, the first thing you have to see that the person should be within the local limits of the court's ordinary jurisdiction. First thing is that. Or he should be not, within less than 50 miles, or if transportation is available, less than 200 miles distance from the courthouse. Then if it is a Pardanasheen woman or you are exempted under any of the provisions of the code, section 133, then the court cannot call you for personal appearance. So first, you should either be within the local jurisdiction of that court, or secondly, you should be at 50 miles, less than 50 miles away from the courthouse, or if transportation facilities are there, maximum 200 miles distance. Then there are certain categories of people who have been exempted under the code. Section 133 is an example, or a Pardanasheen woman or a woman who ordinarily does not come out in public, they are not required to come for personal appearance. And rule number 5 says that what is the need of summons? Summons can be for two things. First, for settlement of issues, or for final disposal of the case, and court will decide in what case what kind of thing has to be given. And the important thing is that a small causes court, if it is issuing a summons, it will only be for a final disposal. Now, rule 6 is that it will be fixing the date of appearance of the defendant. And while you are fixing the date, you have to keep in mind the business of the court, that that's not the only case that the court is dealing with. It has n number of cases, so it will decide accordingly. Then where the plaintiff lives, what is the time required that he can get the service of the summons and he has reasonable time to come and appear. All these factors are to be kept in mind while fixing the date of appearance of the defendant. Now, summons, rule 7 is stating that whatever summons you are giving, you can also give to a defendant to produce the documents that he is relying. Summons can also call for the documents that the defendant is relying. Rule number 8 is saying that if it is a final disposal summons, there the defendant can be directed that on the day you are appearing, please bring all your witnesses that you want to bring in your support. And rule number 9 is an important one, that here you will see how the summons is being delivered. Summons is being delivered by court when what will be there, either you're giving it to the defendant or any agent who is empowered to accept summons on his behalf. If they are residing within the court's jurisdiction, you'll go and deliver to him, otherwise unless directed. And who will do so? By proper officer or his subordinates, or by courier services. You can also do by registered post, which is done by acknowledgement, which has an acknowledgement due, a registered post where you will take an acknowledgement by the receiver, or by fax, message, email, which is addressed to the defendant or agents, etc. And these, what mode will be used will be done in accordance to the High Court rules and whatever has been approved by the High Court or the court record. And the service of summons always takes place at the expenses of the plaintiff. And if the defendant is residing outside the court's jurisdiction, there the summons will be sent by the officer of a court in whose jurisdiction that person is residing. Now, if a person to whom I have sent a summons, if I'm sending you a summons, you're refusing to endorse that you have received it, or you're refusing to take its delivery, this court, after hearing all these factors, will then declare that, okay, even though you have not signed, even though you have refused taking the summons will be taken to have been duly served. This is an important section, that is delivery of summons by court. Then we go on to rule 9A. So apart from rule 9, where the delivery of summons is being done by the court, summons can be given to a plaintiff where he can go and give it to them. So in addition to rule 9, plaintiff can apply that he will effect the service on the defendant, and the court may permit such a service. What he will do, he will either deliver or tender a copy personally to the defendant, or he will use other means, fax, post, whatever has been approved by the court. Here also rule 16 and 18 will be applicable. If summon is refused, or he's trying to escape, etc., here also court will listen to all the circumstances and facts and will deem it to be served. Now, rule number 10 is mode of service. You have to deliver a copy which has been signed and sealed by the court. Now, rule number 11 says that if there are several defendants, each of them should be serviced as summon. Rule number 12 says that as far as possible, you should serve on the person or his agent. Rule number 13 says that if it is, you can service on an agent by whom the defendant is carrying on business in the particular court's jurisdiction when the person himself is not residing within the local limits of the court. Now, you can also serve summons on those agents who are in charge of immovable property if it is a suit relating to immovable property. Now, rule number 15 says that if the person is absent, you cannot find him, you're trying for reasonable time, and there's no likelihood that when you can find him, and you cannot find any agent, then you can service it on his residence. You can go and give it to any adult member of the family. It does not matter whether that person is a male or a female. Whoever is residing with him, you can go and give that person. However, for this rule, it is important that service on a servant or a house help will not work, because a servant is not taken to be a family member. So rule 16 states that the person will also need to sign an acknowledgement that yes, I have been served. Now, rule number 17 says that procedure when there's a refusal to accept the service, you cannot be found. No agent is found. Nobody is found. You cannot find any person on whom you can service the summons to. Then you'll take a copy of the summons. You'll go and affix it on the outer door or conspicuous part of the house where that person already resides, carries on business or works through again. And then you'll go back to the original court. You'll report that why you had to affix it, why it was done, who was the person who told you, who was the person, what is his address that told you that this is that person's house, etc. You have to tell all of that too. Now, rule number 18 is telling you that you have to endorse the time and manner of service. Now, who was the person who identified that this is the person on whom you have to serve it? Who was the person who has witnessed that this particular summons has been delivered, etc. All these things have to be owed to the court. Now, rule number 19 is telling about examination of the serving officer. When you are seeing under rule 17, what did we see in the rule 17? Where you are affixing it on the part of the house or conspicuous part of the house, etc. And there's no supporting affidavit by the serving officer on oath or on verification that why did he do so. Then at that point of time, you have to examine the serving officer so that it can be properly declared that yes, even though there was no person found by affixation, the summons have been taken to be duly served. And rule number 20 is about substituted service. Now, rule number 20 is talking about substituted service, which states that when the court is satisfied that there's a reason to believe that the defendant is doing that, he's trying his best to avoid service, or there's any other reason that you cannot serve the summons in an ordinary way, then what will happen? You can order the affixation in the part of his house where he was last residing or where he does business, gain, etc. And also service that go by advertisement in a newspaper in a locality where that person is actually a voluntary residing, does business, gain, etc. And this type of substituted service will also be effective as service made personally. And here, whenever such service is done, here also a time for appearance will be fixed. Now, next, the rules number 21 and 29 and section 28 and 29, you can go on your own. That is about service of summons in special cases. Like section 28 is talking about when the defendant is in another state, what will you do? That state's rule will apply. When that court is receiving, it will proceed as if itself it has issued it, and then it will return back the summons. If it has taken, it has undertaken certain proceedings in regards to the issue of summons, it will send a copy of the proceedings also. And if any language problem is there, like here from Jharkhand court or a Bihar court, it is going to a Tamil Nadu court. There, if the summons is issued in Tamil, and here it is here, there's a language problem, translations, etc. in English, Hindi, as whatever is needed should also be done. Section 29 is dealing with service of foreign summons. Rule 21 to 29 are special cases when he's serving the military, etc., and all those situations. And Rule 30 is talking about substitution for letter of summons. Now, anything notwithstanding the entire order, if there is something, you can substitute a summon with a letter which is signed by the judge or officer appointed in its behalf. It should contain all the particulars, whatever is contained in the summons, and you can send it by post, session messenger of the court, or any manner it deems fit, and deliver it to the defendant or the agent. I understand this is a long section, but let's rewind a little bit so that we can remember it better. So the first thing was that firstly, we need to remember that what are summons? What are we doing by summons? We are calling that person to attend the court on a particular date and time fixed for a certain purpose. Now, for Order 5 and sections 27 and 29 are the relevant one here. Order 16 and Section 31 deals with summons for witnesses. Section 27 and Rule 1 are telling you not beyond 30 days from the date of institution, you have to serve a summons to the defendant, and by that time he has to come and file his reply also. If he is not filing his reply, another 30 days can be given by the court. And how will he appear in the court? He'll appear by person, pleader, etc. And the summons should be signed by a judge or officer of the court and should have the seal. Rule number 2 tells you that you should also, with the summons, a plaint should be there, so that the person, if the party is able to understand that why is he being called, what is the case all about, he's also able to understand that. Then personal appearance, we saw that the court can call for personal appearance. Rule 4 is telling when you are not allowed to call for personal appearance, and other sections also which tells you what persons you cannot call for personal appearance, what kind of summons will be there. You either settle issues or it is for final disposal. Small causes is always for final disposal. So rule number 6 is telling you that you have to fix the appearance date and time in accordance, taking all the factors in consideration. Rule number 7 is also stating that summons can be issued for production of documents relied. And rule number 8 is about final disposal. Summons can be given there. You'll be called, the defendant will be called to bring all his witnesses. Rule number 9. Now this was still rule number 1 to 8. We are understanding what is all about, what is going on in the summons, etc. Now we are seeing about the delivery part. Rule number 9, firstly we see, first we'll attempt by the court. Apart from the court, under rule 9A, we can see with the help of the plaintiff also can be, can also be volunteering, or he may want to service the particular summons. Then how are we serving it? We are delivering or tendering a copy. Then how are we serving? Rule 11, 12, 13 and 14 are about different types of situations. If there are several defendants, serve on all. If there is a person, then try to serve it to the person or his agent. If his agent is here but he is outside, then serve it on the agent. For agent involved, for responsible for in charge of immovable property, then serve it on that agent. Now if that is person, now what we saw, first the court is trying to do so on the person and his agent. The plaintiff is also trying to do the same. That was rule 9 and 9A. Next, we go on to rule number 50. If we cannot find the defendant or his agent, you are no likelihood where you can find him. What you'll do, next you'll go to his house. There what you'll do, that person is not there, but you'll find any other adult member, male or female, and then give it to that person. Servant, if you serve the summons to, that will not be a valid service of summons. Now, what happens? If this particular person is not there, then what we'll do, you go and affix a copy on his door or any conspicuous house or place of the house and tell the court. Now, even if this is not happening, for example, you see under rule 20, there's a substituted service where the court is feeling that he is doing that purposefully to try and avoid doing so or any other reasons, then again it will order a fixation and there'll be no attempt to be made again that find that person or his agent, and just affix that and will be taken that summons have been served personally. So how way of serving summons? First, the court is delivering, plaintiff is delivering, can't find them, nothing is happening, go to the house, give it to an adult member, male or female, but not a servant. Still cannot find, go and stick that there. And if court is feeling under rule 20 that no, he is doing it purposefully or any other reason, first he go and do that affixation. If required, can also call for circulation in the local newspapers. Now, this we understood how the delivery was taking place. Then we will also see that what happens when the summons has been delivered. Whenever the summons has been delivered, what you will see that the person has to sign an acknowledgement that yes, I did get this thing. They have to just also write about who was the person who was served, how did I identify, the server will tell how did I identify who was the person who told me that this is the person. If under rule 17 there was no person, he went to affix that place, he has to come on and on affidavit, on oath, on verification, he has to tell that such and such circumstances happened and this is why I had to affix it. If he has not done so, it is very important to examine the serving officer. Why we are talking about examining the serving officer? Because it is very important that the summons have been duly served. This is an important part, because the moment a defendant comes up and tells you that I did not even get this summons, that will vitiate the entire cause, because unless he knows that he has been called, how will he come to court? So service of summons is an important part. This is why if under rule 17 there's a return, then the examination of serving officer also becomes important. Now, Rule 21 to 29 and sections 28 to 29 are the special cases. 28 I've explained a little bit, and 29 is about service of foreign summons. You can go through them. And Rule 30 is when you can substitute summons with a letter. The letter also should contain all the particulars that are required to be stated in a summons, and it should also have a signature. And how it will be sent will be decided as well. So in a nutshell, you know that after suit institution, dependent has to appear and answer. How it will be done? By issuing a summons within 30 days, maximum 30 days extension. Always a summons will be accompanied by a plain sign and seal of the court will be there. He'll appear in person, pleader, etc. whatever mode. Summons can be for settlement of issue or final disposal. Small causes only for final disposal. You can order personal appearance. Exceptions for appearance you have to just keep in mind. Production of documents or witness can be there. You can call for direct or personal service. That will be under rules 10 to 16. Your court can call you, plaintiff can call you under Rule 9A. Then substituted service is under Rule 17 and 19 and 20. You have to see all of that. An acknowledgement is needed, needs to be signed, examination is important, all that is there. So this in totality was all about summons. We moved on from pleadings to summons. Summons become important because if a summons has not been established to be properly served, we cannot proceed forward because the defendant has a valid ground in saying that I was not served the summons, I had no idea what to do. That is why you cannot, then you will not be able to proceed. So summons becomes important, and the relevant rule and order, that is Order 5 and sections section 26 to 26 and section 27 to 29 it becomes important. Now moving on to the next topic, we moved on from written statement, set off, counterclaim. Now we have served the summons. Now next what? Now we have served the summons. So as soon as you ensure that the summons has been issued, that means now the parties have to appear in court. Now we are moving on to the next topic, that is appearance and non-appearance of parties. Now this relevant provision for this particular topic is Order 9. Now what happens is we just try to look at it logically. Now I had instituted the suit, the plaint was accepted, summons was issued. Now we know the summons was issued, that means the parties have to appear because the date and time was fixed. So here under Order 9, Rule 1, parties have to appear on the date fixed in the summons, where they have to appear and answer. Both parties need to be in appearance, either by person or by the pleaders. And on that day, the suit will be heard, unless for certain reasons it gets adjourned for a future date, which is fixed by the court, where the court has not been able to complete the proceedings, or it feels that today there's some problem, and then it will give you time and move forward. Then Rule number 2 says that this is an important rule, and Rule number 2 says that when a suit can be dismissed, when summons. How will be summons? We had read that it is on the plaintiff's cost. The plaintiff has to pay the cost for the postal fees or the court fees, etc. Then only the summons will be issued. Now, if summons have not been served because the plaintiff failed to pay the cost, then the suit will be dismissed. This is Rule 2. Rule 3 is saying that if nobody is appearing, obviously the suit will be dismissed. Rule number 4 says that if any dismissal under Rule 2, where there was no payment of fees, etc., because of which summons had not been done, or Rule number 3, where none of them had appeared, plaintiff can bring a fresh suit, or he can apply for setting aside the dismissal of the suit. And if the court feels that there are sufficient reasons for doing so, they'll set aside the dismissal order and fix a new date. So for Rule 2 and 3, where there's a dismissal of suit on the grounds that the summons was not able to be served because of the plaintiff's failure to pay the cost, or nobody appeared at that point of time, either the plaintiff, against it, either the plaintiff, and the suit is dismissed, the plaintiff can bring a fresh suit or can apply for setting aside that order of dismissal. Important point to remember, when you can, in this particular order, you have to remember at what points the plaintiff can bring a fresh suit and at what points he can apply for dismissal, or at what points he can do both. So for Rule 2 and Rule 3 dismissal, he can do both, whatever he wants. Now, Rule 5, dismissal of suit when after summons have remained unserved. dismissal of suit when summons remain unserved. Now, if within 7, what happens? Summons have been tried to be served to the defendant, but because of some reason it could not be served and returned back empty-handed, that the summons could not be served. This was the noting of the server. Now, within 7 days of such return, if the plaintiff has not applied for fresh service of summons, court can make an order for dismissal against such defendant unless plaintiff has shown that he tried his best and he could not find his residence, etc., or the defendant is purposely trying to avoid service, or any other sufficient cause for which the court may end the time. Here also, fresh suit subject to limitation can be brought. So here we are seeing again the duty of the plaintiff, that if for any reason there has been a return of summons without it getting properly served, or the person server could not find the person on the address given by the plaintiff, etc., within the 7 days, again the plaintiff has to apply for issuing another summons. If this has not been done, then this court will make an order for dismissal against that. If there are many defendants and against one defendant this summons has not been serviced and the plaintiff has also not applied for fresh issue of summons, then the court will dismiss against this defendant. But here also the plaintiff can show that he could not find a residence, even though he could find his best, defendant is purposely trying to do so, or any other reasons, then the court may extend time. On this dismissal also, fresh suit can be brought against that particular defendant or defendants, but it would be subject to limitation. Now, rule number 6 is saying that when only the plaintiff is appearing and the defendant did not appear when the suit was called. First, if the summons was duly served, the court will proceed ex parte, that is without the defendant. If the summons was not duly served, the court will issue the second summons. Third, if the summons was served with not due time, there was not enough time for the defendant to appear, here there will be a post movement to a further date, and such further date's notice will be given to the defendant. Now, if this was because of the plaintiff's default that the summons was not served within particular time, or it was not served within sufficient time, court can order the plaintiff to pay cost for such postponement. Now, rule 7 happens that if the plaintiff is appearing before or on the date or the adjourned hearing, where previously the suit was heard ex parte, and he comes here and tells that there was such and such reason why I could not appear previously, court may, with or without cause, hear him, and he'll be heard as if he has appeared on the previous date. Now, rule number 8 is talking about the procedure when only the defendant is appearing. Here, the court will say that if only the defendant is appearing, the suit will again be dismissed, unless the defendant himself is saying, I admit certain parts of the claim, or I'm admitting the entire claim, then in accordance to that, a judgment and a decree will be drawn and the rest of the suit will be dismissed. Rule 9 is saying that if a decree against plaintiff by default bars fresh suit. So here you will see that if a dismissal has taken place under rule 8, that is when the plaintiff did not appear and the defendant appeared, here you cannot go for a fresh suit. However, you can apply for setting aside the order of the dismissal, and if court is satisfied with the reasons, then with or without cause, it may set aside the dismissal order and fix another date. And here, whenever you are doing so, whenever you are setting aside the dismissal, you have to give notice to the other party so that he also knows that, okay, now again I have to come and answer this. Now, rule number 10 says that if there is non-appearance of one or several plaintiffs out of many, some have appeared, some did not appear, at the instance of an appearing plaintiff or plaintiffs, suit may be permitted to proceed as if all the plaintiffs had appeared. Now, rule number 10 is saying that if one or more or several defendants were there, they are not appearing, then the court at the time of pronouncing judgment may also pass orders or whatever it feels fit in respect of the defendants who did not appear. Now, what does rule number 12 says that if you are not appearing, you are not even giving sufficient reason, that if you were ordered, and especially if you were ordered to appear in person, you have to either show reasons why you did not appear or you have to appear. If you're not doing so, then if you're a plaintiff, then according to what your non-appearance will entail, if you're a plaintiff, then this will be dismissed. If you're a defendant, you did not appear, ex parte proceeding will go on, that would be applicable. Rule 13 is talking about setting aside the decree ex parte against defendant. defendant. So you saw that when the plaintiff is appearing, the summons have been duly served, their ex parte proceedings will take place. Here, the defendant may apply for setting aside the decree which has been passed ex parte against the defendant. He will apply to the court which has passed the decree. He'll ask it to set it aside, and the court, if he feels that the summons was not duly served, or he was prevented by sufficient means or cause from appearing in the court, the court will set aside the decree and may order some cost if it feels so, which may be paid into the court or otherwise as the court thinks fit, and appoint a day for proceeding with the suit. Provided, for example, if the decree is such of nature that it cannot be set aside only against the defendant, then it can be also be set aside against all the other defendants. So now it will be no setting aside of an ex parte decree will be done on the grounds that there was an irregular service of summons. Irregular service of summons is when that, okay, there was some fault in the process of service of summons, but however, the defendant knew that this is the date of hearing and he did have sufficient time to appear and he still did not come. He just said that no, there was irregularity, that is why I have not come. In that case, you cannot be allowed to set aside your ex parte decree. Now, if you have preferred an appeal against a decree that has been passed ex parte, and that appeal has been disposed of has been disposed of on certain grounds other than the grounds that the appellant has withdrawn the appeal, no application shall lie for setting aside an ex parte decree. If you have gone for appeal, you cannot come here and ask for setting aside an ex parte decree. Now, rule number 14 is saying a simple thing that no decree can be set aside without giving notice to the opposite party. So what is an ex parte decree? It is a decree which is passed in absence of the defendant. What are the remedies against such decree? You go under rule 13, as you know, or you can appeal against such decree under section 96(2), or you can file a review under orders 47 rule 1, or you can file a fresh suit, but only on the grounds of fraud. Otherwise, no fresh suit can be filed to set aside an ex parte decree. For setting aside an ex parte decree, you can show fraudulently how you were done, so and so. On that ground only, you can file a suit. And what is the limitation period for applying for setting aside such a decree? That is 30 days from it. That is given under Article 123 of the Limitation Act. Then the next thing is that what is the effect of setting aside an ex parte decree? Suit will proceed as if it was before the decree. Trial will start de novo. Whatever proceedings had taken place, whatever witnesses you had examined or documents you had taken on record ex parte, that will not be taken into consideration. You have to start afresh. That is de novo. So ex parte decree is also a decree. So that is why appeal under section 96 clause 2 is a. Here I have not actually completed the in a nutshell part of it, but we'll still go back to it. In short, let's try and understand what did we understand in order 9. Now first we have to understand, because there is a summons, you need to appear. So the first point under rule 1 is that both the parties have to appear. Whenever you are called, whenever there is a date fixed, both of them have to appear. Rule 2 is telling when the summons has not been able to serve because the plaintiff did not pay the cost, etc., the suit will be dismissed. Third rule is saying nobody has appeared, again dismissed. Rule 4 is dealing with rule 2 and 3. Here plaintiff is allowed to bring a fresh suit or pray for setting aside such dismissal order. So first, both the parties appearing. Then second, plaintiff, there was no appearance on part of the defendant because summons was not served because of the plaintiff's fault. Third, nobody has appeared. Fourth is what will you do when such thing under rule 2 and 3 is happened. Rule 5, if summons has remained, it is talking about the plaintiff's responsibility, that if the summons have remained unserved, within 7 days you should apply for a fresh service. If you are not doing so, again the suit will be dismissed against such a defendant unless you are able to show reasons. And here also you can bring a fresh suit. Now what happens under rule 6? If only the plaintiff is appearing, then you have to see 3 things. If whether the summons have been served, it has been served duly, then you can proceed ex parte. If it has not been served, second issue of summons. If it has not been served within due time, served but not within due time is not there, you'll fix another date. Rule number 7 is when the defendant is appearing against an ex parte decree, he is coming and telling why he did not come. Then on the next date will be taken as if he had appeared on the previous date. Now rule number 8, what is happening when the defendant is appearing here either So rule number 8, where you're seeing again that when the defendant only is appearing, again the suit will be dismissed unless defendant himself is admitting a part. And rule number 9 is saying if you are not coming but the defendant is coming, then you cannot bring a fresh suit. Rule number 10 is talking about when some of the defendants or some of the plaintiffs are not appearing. Rule number 11, when some of the defendants are not appearing. Rule number 12 is talking what happens if you're not appearing when you're not giving any sufficient cause. So you either you appear or you give a reason. If you're not doing so, the dismissal or whatever has to, or proceeding of ex parte will take place depending on whether you are a plaintiff or a defendant. Rule number 30 is an important rule. In what circumstance can you set aside a defendant's ex parte decree which has been passed against a defendant? And rule number 14 is that you cannot set aside anything without giving notice to a party. And what are the remedies that are there against an ex parte decree? Rule number 13, appeal against such decree under orders under section 96. To review under Order 47, Rule 1. You cannot bring a fresh suit here except on the grounds that there were certain fraudulent actions by which we were prevented, etc. And on that grounds, you can bring a fresh suit. What is the limitation period, etc. So again, putting it in one line, appearance and non-appearance of parties under Order 9. First, you see, just go by it logically. Simply, if the court is calling, obviously both of you have to appear. If none of you are appearing, obviously it will be dismissed. If the summons is not served because of the plaintiff, so obviously it will be dismissed. Then there should be a remedy for these certain circumstances. So Rule 4 is dealing with that. Then what happens if only the plaintiff has appeared? Then we'll check whether summons had been served or not, or time was given or not, etc. Accordingly, we'll proceed. Then what happens if only the defendant is appearing? What happens if there are a huge number of defendants and plaintiffs and some of them are not appearing? You will see that particular situation. What happens if you are not appearing and not giving reasons? That also has to be dealt under the rule. And obviously, without notice, you shouldn't be doing so. And then ex parte decree becomes quite important. Why? Because the defendant becomes liable to pay something or do something, or there is relief that has been sanctioned against him, awarded against him, or given against him. So setting aside of ex parte decree is also important. There should be a situation where, for valid reasons, he should be able to get that decree set aside. So this was what was under Order 9. So today, I have not made the in a nutshell part for this order. I'll try to include that tomorrow. But today, what we in general saw was that we went back, we rewinded back on what is written statement, we talked about a set of counterclaim. Then we saw after we have done with the pleadings, obviously the next logical step would be issuing of summons, when you're issuing a summons to a party. And after the summons is issued, obviously you'll be talking about whether the party is appearing or non-appearing. So this was the gist of the entire class that we did today. I hope all of this is clear. Any doubt, anything that I might have missed out, or any mistake that I have made, please let me know in the comments. And tomorrow or in the next class, we will deal with the next topics, moving on that what should be the next topic after appearance and non-appearance. Again, another thing, whenever you're dealing with CPC, you should try and look at it at a logical sequence. Just try and understand, just apply logic that, okay, now if I've understood which court I have to go to, how will I go to the court? What should I write in my thing? Then after I've written, after they have accepted what I said, what should be the next thing they will do? There's obviously issue a summons. After issuing a summons, what should happen? Obviously the party should appear. So what will the next thing? The next case we can talk about what will happen in the first hearing. So this is how it takes place. I hope till now all the lectures, again a disclaimer about lecture 2, if anybody has not watched it yet, is that there are certain audio issues. I really apologize for that. But I hope till now all the lectures are clear. There's no fault with all of them. And I'm trying to keep it as brief and concise as possible, not dealing with case laws now. I'll tell you the reason after I complete in all the topics. And this is all for today. Thank you. And hope to see you in the next class. Thank you.